All right. Good morning, everybody. I am Dana Sparks, and I am the director of the Real Estate Academy of America, which is the school offering this course for CE credit. Formerly, we were the Georgia Real Estate Academy, so I need to change my background. But we are now the Real Estate Academy of America. Same great classes, same Georgia Real Estate Commission school numbers, same great instructors, just a new name. So welcome everybody. This class is the 2023 GAR, Georgia Association of Realtors Contract Changes, GREC course number 75552. I'm excited to welcome y'all. This is the first time this class has been taught. Just a little caveat. The school has paid GAR for the training versions of the contracts. As of the time of this class, I do not have copies of all of those. For those of you who have been in my classes before, you guys know I like to share the actual document with my red underlines to point out what the changes are. I do not have all of those forms to share with you at this class. However, I am going to present to you in the PowerPoint the changes that the Georgia Association of Realtors has made in the contract package, all the forms for 2023. I'm not going to go over all of the changes. I am going to go over the changes in the forms that I have found are the most relevant to the majority of agents' residential practice in real estate. I am also the qualifying broker of the Maximum One Greater Atlanta Realtors. So I am what's called a non-competing broker, meaning I don't actually help the public buy or sell anymore. I just help agents with the buying public and buying and selling public. And I teach and I manage the company. So, but I am still aware of everything that's going on and a lot of the changes. So let's dive in. I am going to share the PowerPoint. And I do have copies of handouts available to you. They're not necessary right now. And again, when the school, the Real Estate Academy of America, does actually get the full training version of the 23 GAR contract package, I will go through all of those and underline them and post those where you guys can have availability to them. But let's get started. I'm going to share my screen and we are going to dive in. I am monitoring the chat, so if you have questions, feel free to type them in the chat and let's dive in. All right, let me get rid of this. So here we go. Let me make this small. Let's make that go away. All right, 2023 GAR, Georgia Association of Realtors Contract Changes, GREC course number 75552, hosted by Maximum One Greater Atlanta Realtors. The CE credit is offered through the Real Estate Academy of America, and I am the instructor, Dana Sparks. I am the director of the school as well as qualifying broker of Maximum One Greater Atlanta Realtors. So the notice to students, this obviously is a virtual broadcast of a CE class that has been approved by GREC and through the school. I got to change that. Real Estate Academy of America. It is still GREC school number 6915. We have just renewed, so the school is renewed through December 31st, 2026. This is the course number. CE credit, 3-hour CE credit, no prerequisites, no tests. I'm the instructor, no homework. Attendance, the way we do attendance for a virtual class through our school is via the chat function. Now, Zoom, the software program itself, does keep track of your computer's connection to the class. We know there are technical difficulties and sometimes an internet will blink out and blink back on. So it keeps track of all of that. So we do that through your registration, through the software where it keeps track of your computer being connected, and through the chat function. So the way we keep track of attendance through the chat function is at the beginning of class, when we get back from break, and one last time before you leave, if you will type in, if you've already done so, you don't need to do it again, but if you'll type in your name, your real estate license number, your email address, and your phone number. We need your contact information in case we have issues recording your CE credit. And also, there are times when I might be in a position to email you guys copies of the handouts when I get them. So again, now, if you've already done it, you don't need to do it again when you get back from break and before you leave. Also, I will ask questions throughout the course. Go ahead in the chat function and type in your answer. Even in the interest of time, if I've gone on and given you the answer, go ahead and type in your answer anyway, so that we do have a record of you actually paying attention to the class and not just having logged on, walking away for 3 hours and coming back. Students may only receive credit for a specific course number once every 12 months. If you've already received credit for this course, which you have not, this is the first time we are teaching it, you are invited to attend, but will not receive additional credits. Please note that we have various instructors through our school teaching it, including a lot of closing attorneys. We will be teaching this class throughout December of 2022, January and February of 2023. So if you choose to take this class again with additional commentary from a closing attorney, you are more than welcome to do so, but you'll only get CE credit, 3-hour CE credit for it one time, and no recruiting. All right, we are going to dive in. The class is going to cover not only the changes to the 2023 GAR contract package, but also the changes that GAR made mid-year last year, which was May of 2022. A lot of you agents, if you are actively using the contracts, you will have noticed those changes. If not, a lot of times everybody takes a new contracts class at the beginning of the year and fails to take another class after GAR releases their mid-year changes. So we're going to cover 2 sets of changes in this class, and I think you guys will like it. I hope so. For 2023, the cost for non-realtors is $259. If you are a realtor, then you are paying for the licensing agreement to use these contracts through your membership, your local board membership dues. Part of that money also goes to the state level, which is GAR, which does cover the cost for the licensing agreement for 2023. They will be available online January 1st of 2023 through whatever means you use to access your contracts, whether that be through Remind Docs Plus, Transaction Desk. Some of you are with brokers that have .loop. Wherever it is that you access your contract forms, you should have access to the 2023 contract forms as well. Per GAR's licensing agreement, once the 2023 forms are released, it is a licensing violation to use GAR forms with any previous date. And it doesn't have anything to do, it doesn't interfere with the enforceability of the contract between the buyer and the seller, but it does have implications for your use of the forms and your broker's use of the forms. GAR can revoke that use even if you have paid for them if you violate their licensing agreement. Now, what does this mean? This means if you get a listing agreement signed now and that listing carries over into next year, you don't need to terminate that agreement and redo an agreement. If you have a property, if you have a transaction under contract, you don't need to redo forms. It just means that any forms you initiate after the 2023 forms are released, that those terms, you must use the 2023 forms at that point, but you don't have to go back and redo any of your stuff. So some agents and some brokers, for whatever reason, download and copy the GAR forms into their computer. I do it, but I download the training versions for training purposes. If you have downloaded those forms for whatever reason to use with the public in your transactions in your business, you may not use those next year. All right. And again, I just covered this, that you are authorized to use those forms if you are a realtor or if you have paid GAR to use them. And the other alternatives are if you are a co-op agent in a transaction, the co-op agent can share the forms with you as long as your name is on the signature page, but your broker may not just share a copy of the forms that the broker has paid for. And I also have a reference there to the GAR website as well as the NAR website. Those are easy to find also if you just Google Georgia Association of Realtors or National Association of Realtors. There is a helpline offered through our State Association of Realtors. And again, there's the link, or you can just get it if you Google Georgia Association of Realtors. You must be a realtor, however, to access this, because you need to input your NRDS number to get a link directly to the legal counsel to GAR, which at this point in time is Christina Chow and Seth Weissman. There might be others, but I know of those two specifically. Again, the changes are outlined wherever you guys access your contract forms to pull up a purchase and sale agreement, exhibits, amendments, so forth and so on. There is a document that GAR publishes every year that is called the 2023 GAR form changes. I'm making that available to you through this PowerPoint, through this presentation, and through the link where you can access the handouts. But please know that that is there for you guys to pull up. And when GAR makes their mid-year changes, they will also publish a document which is an outline of the changes they have made. Those are very valuable. As I mentioned, the CE class will cover both the 2022 mid-year changes, along the major changes, not all the typographical changes or spelling changes or syntax changes, but the major changes along with the 2023 changes for GAR. So let's dive in. Actually, let me back up. Before we dive in, I will let you know, well, let's just dive in. Let's cover mid-year 2022 first, and then I'll make my comments. All right. So these were changes. Again, if you were using any of these forms in your practice after May of last year, you're already aware of these. If not, you might not be aware of them. And again, since there are typically, most people take classes like you guys are taking them at the beginning of the year, there's a lot of times, unless your broker has taken them or you have taken a class later, I just want to formally introduce you to some of the changes that GAR made mid-year last year. So in the purchase and sale agreement, the mid-year changes from 2022, part of it has to do with the closing costs. So if a buyer and seller have negotiated and a seller is making a contribution to a buyer's closing costs, they changed it and said that part of that contribution may be used to any commission obligations of the buyer. What does that have to do with? Well, what that means is, in this highly competitive market that we have experienced in 2022, there were a lot of situations where a seller or a seller's broker was not necessarily paying commission for a buyer's broker, and the buyer was obligated to pay by virtue of a buyer brokerage agreement. The buyer was obligated to pay their own broker. And what happened was, if the seller was making a contribution to the closing costs, part of that contribution, after the lender applying it towards closing costs, could be used towards any commission obligations of the buyer, if there was a circumstance where the seller or seller's broker, the co-op commission did not cover all of the buyer broker's commission. Regarding the disbursement of the earnest money, so that was if there was a contract that terminated and the buyer and seller did not agree on the disbursement of the earnest money, and the broker had to interpret the contract and issue a 10-day letter. They added information in the hold harmless section of that part of the contract that basically said that the parties hold the broker harmless from doing their job by interpreting the contract, including claims caused in whole or in part by negligence of the holder. Under inspection, lead-based paint information. I will let you know that in 2023, GAR has readdressed lead-based paint disclosures and requirements by the seller when listing a property for sale. But back in May of 2022, under the inspection, so we're gonna come up with this topic again when I present the 2023 purchase and sale agreement, but I wanted to let you know that they also addressed it under the inspection paragraph in the purchase and sale of last year. GAR added, I have lead spelled incorrectly there. It's supposed to be lead-based paint information. And basically, it says that a buyer has the right to inspect a property, and all of that has been the same. And what they added was, if any portion of the property was built prior to 1978, the lead-based paint exhibit F316 is hereby attached and as an exhibit to the agreement. Buyer shall have the right to conduct a lead hazard evaluation within 10 days from the binding agreement date or other mutually agreed upon time period. And the buyer has the right to terminate this agreement without penalty, meaning they're going to get their earnest money back, upon notice to the seller if lead-based paint and or lead-based paint hazards are found, unless the buyer has waived those rights per what they have signed in that exhibit. If the lead-based paint exhibit gives the buyer the right to terminate this agreement if lead-based paint or lead hazards are found, and such notice of termination is not given within the 10 days from the binding agreement date or other mutually agreed upon time period, then the right to terminate based on lead-based paint is waived. Again, we are going to cover a little bit more of that information as we get to additional changes that they made in 2023. All right. Under also mid-year changes last year under the brokerage, where it talks about commission, it basically says that the brokerage must be shown on, commissions must be shown on the closing statement and reflect the buyer, and that, I'm sorry, the commissions must be shown on the closing statement, and the commissions on the closing statement need to reflect what was already agreed upon between the broker and the buyer or seller in the brokerage agreement. And basically, again, in response to the extremely competitive market that we experienced for the past year or so, that's why these commission changes were made. So basically, in May, I have there for contrast, you can see what was originally in January of 2022. And then in May 1st, 2022, it says brokerage, unless otherwise, I'm at the bottom paragraph here, unless otherwise specified herein, the real estate commissions owing to the seller's broker and buyer's broker, if any, are being paid pursuant to a separate brokerage engagement agreement. In other words, if you are working with a public person as a customer rather than a client, because you have not signed a brokerage agreement, you're not necessarily guaranteed commission paid by that client. Then it goes on to say, buyer and seller agree that any commissions to be paid to the brokers shall be shown on the settlement statement and collected by the closing attorney as a precondition to the buyer and the seller closing on property, so long as the same is permitted by the buyer's mortgage lender, if any. The closing attorney is hereby authorized and directed to pay the broker at closing their respective commissions pursuant to the written instructions from the brokers at closing. What is that referring to? That's referring to that document, instructions to closing attorney, that you guys use to let the closing attorney know how much the brokers are being paid for your efforts working with the public, their respective agreements, so forth and so on. So again, this is just in response to the market that the commissions that each party is paying must be reflected on the closing statement and is a reflection of what's in a brokerage agreement. Also in May, they added a new section in the instructions to the closing attorney to reflect those changes that I just mentioned in the purchase and sale agreement. And it is new section C. And basically, well, specifically, it states the closing attorney is directed to show the above referenced commissions on the settlement statement and to collect the same as a precondition to the parties closing on the purchase and sale of real property, so long as the same is permitted by the buyer's mortgage lender, if any. Again, that's just a reflection on the instructions to reflect those changes. All right, this also is addressed. The amendatory clause is addressed in the 2023 GAR contracts when they talk about on the FHA and VA loan exhibits. But basically, what this states, this amendatory clause, so we know if a buyer is getting an FHA insured loan or a VA insured loan, those are government, federal government agencies that are insuring the buyer's loan. Because the government is involved, they have what's called an amendatory clause. So a couple of things regarding this. Number one, the government, entities of the government, the Federal Housing Authority and the Veterans Administration are insuring the loan to the lender. So this amendatory clause, in essence, is the appraisal contingency for a buyer getting an FHA or VA loan. And just to review, there is no time frame in here. A buyer of an FHA and VA buyer have rights to their earnest money if the property, if they're getting these types of loans, if the property appraises for less than sale price. So in other words, if you get a low appraisal, lower than contract sale price, an FHA or VA buyer may terminate the contract through day of closing. There's no time frame on this. It goes through day of closing with no penalty. In other words, they will get their earnest money back. Now, you buyer's agents, you have to send notice of termination. An FHA and VA buyer just cannot not show up at closing because of a low appraisal and expect to get their earnest money back. They must send notice of termination prior to, yes, USDA is a government insured loan, so this does apply to those as well. USDA guidelines really fall under FHA guidelines. So what GAR added in May of 2022 is just for clarification purposes. This has always been the case because the federal agencies override any written agreement between a buyer and a seller because it's federal regulations. So GAR added this last statements in here that I have underlined on this slide for clarification purposes to agents and to the buyers and the sellers. This amendatory clause shall apply even after the financing contingency period has terminated. I'm sorry, this also applies. They've added additional information in January where it also says these amendatory clauses apply, they prevail through closing. I'm getting tongue-tied. These take precedence over the contract in and of itself. So on the exhibits itself, GAR added that these apply even when the financing contingency period has terminated. Number one, it's an appraisal contingency, not a financing contingency. And number two, there's no time frame. So it goes through day of closing, regardless of the time frame for the financing contingency. But basically, again, government insured government regulations supersede the contract. So even if a buyer adds a special stipulation in the purchase and sale agreement, what we lovingly refer to as the appraisal gap stipulation, that the buyer says, if the property appraises for less than sale price, they promise to bring cash for the difference and go ahead through closing. Even if a buyer has that as a special stipulation, if the buyer is getting an FHA insured loan or a VA insured loan, that is not enforceable. It's trickeration for you listing agents. And that is not, I don't have that on this slide. That's actually written in the purchase and sale agreement, but just wanted to mention that while we are here. Moving along, if you have a closing attorney that is the holder of the earnest money, in May of last year, they added information that the closing attorney may not deduct their actual attorney's costs or fees from the trust money. Now, if the closing attorney does have to interplead the earnest money into a court to make a decision regarding the disbursement, the closing attorney or any holder is allowed to deduct the court costs and fees associated with having to interplead the funds. But a closing attorney cannot deduct just their fees for performing their obligations as for closing the transaction. They cannot deduct those fees from the earnest money or any other trust funds. And in the seller's brokerage agreement, we used to refer to as a listing agreement. They did add verbiage about sharing commission with the co-op broker only if it's specified. So under the paragraph, under the brokerage paragraph where it talks about sharing brokerage commission with co-op broker, it specifically states, if specified in section herein, broker shall share agreement with co-op broker, and none of that had changed. And then it goes on to say, if this agreement specifies that no commission is being paid by the seller's broker to the cooperating broker, then no such commission obligation shall exist. And again, this is in response to the market that we faced in 2022 where a lot of sellers and listing brokers were not sharing a commission with a broker representing a buyer. The buyer had to get paid their commission by the buyer. And it also in the paragraph about commission went on to say that nothing herein shall prevent a broker from being paid a commission in excess of the commission reflected herein or being paid a bonus if the same is offered by the seller or seller's broker. Buyer agrees that any commission, this is in the buyer brokerage agreement, buyer agrees that any commission to be paid by the buyer shall be shown on the settlement statement collected by the closing attorney. We've seen that verbiage before. But basically what it is saying is that if you, the broker representing the buyer, if there was an offer of a bonus, you are allowed, or the seller or listing broker was willing to pay you more, you were allowed to take the additional commission. And in May of 2022, under the mutual termination of the brokerage agreement, this was just a content error. If the client with whom your broker is working with and your broker mutually terminate the brokerage agreement, in other words, decide to mutually terminate a buyer brokerage agreement or a listing agreement, there is a place on this document, GAR F152, where you write out any fees that the public client buyer or public client seller agree to pay the broker for the early termination of that agreement. And in doing so, once that compensation has been negotiated and agreed upon, there is no protection period for your commission should this public buyer or public seller choose to work with another broker. And that was always the content, but they just removed it from the form because you're negotiating payment now. So you don't get paid now and then also get paid a future commission. And in the residential lease last year, they added verbiage that if the landlord terminates the contract early, it says landlord shall owe no early termination fee to the tenant if landlord's early termination is due to a default under the lease by the tenant or the premises becoming uninhabitable due to an event of destruction as set forth in C7 of the lease. Now, again, in response to the very fast, highly competitive market that we have been in, there were a lot of situations as addressed with commission where the buyer was obligated to pay their broker commission rather than the buyer's broker receiving commission being shared by the seller's broker. A lot of buyers, agents slash brokers said they did not want to charge their buyers a commission. They were going to accept any commission paid to them by the listing broker, the seller's broker. So GAR created a special stipulation that basically says, notwithstanding any provision to the contrary contained in this agreement. And again, this is a special stipulation really that should be used in the buyer brokerage agreement, not a purchase and sale agreement. But that was the intent. Notwithstanding any provision to the contrary contained in this agreement, brokers shall not look for the buyer to pay any portion of broker's commission pursuant to this exclusive buyer brokerage engagement agreement. You agents, you need to check with your broker and your broker's policies before using this special stipulation in a buyer brokerage agreement. Okay, I've got a question. Are referral fees to a third-party agent, and I think you mean broker, referral fees can only be paid broker to broker, required to be specified on a closing statement? No, because referral fees go to the broker that is the broker on the purchase and sale agreement. The referral fee comes to that broker. It is a separate agreement between that broker to pay a referring broker. So that is a separate agreement outside of the buyer and the seller. That's the money that one of the brokers gets, either the seller's broker or the buyer's broker gets from the transaction. And then there is a separate agreement not having to do with the public, just broker to broker, where they have arranged for compensation for a referral. So great question, Cindy. Thank you. All right. New in May of 2022. If you agents are working with buyers that are purchasing a condo, please, please, please be aware of this special stipulation. There is a new special stipulation that makes the transaction contingent upon receiving the condominium questionnaire. So I'm not going to read this verbatim, but just know that this is in existence. Please protect your buyers buying a condo. Please protect their earnest money by making this contingency if you do not have the condo questionnaire at time of writing the offer. All right. Those were the major changes that they made in May of last year. And now on to 2023. Dun, da, da. Happy New Year. I will let you guys know that there were not a lot of changes for 2023, a lot of clarification changes. There were some major changes to the financing contingency exhibits, but not content-wise, more just format-wise and what they look like. So we're going to go over that so you don't get caught unawares when you are in front of your clients filling out those contracts and you're like, ooh, what? And you don't misunderstand anything. So we're going to talk about that. Pretty substantial changes to the temporary occupancy agreement. Major changes to the all cash exhibit. Let me see what else. Major changes to the option agreement, but I'm not really going to go over that. I'm going to mention it, but I have not seen that used a lot in the past couple of years anyway. And well, you'll see. We'll go on, but not a whole lot of changes, but ones you need to be aware of and plenty to fill up the CE class. So Happy New Year early, and here we go. Again, not a ton of changes. 2 new forms and no new special stipulations. This is, as I mentioned at the beginning, this is an index of the 2023 GAR forms changes. This is available to you guys. I'm going to put one more time in the chat where you can access the handouts. They are not required, but you will have access to them. And as I get additional documents, I will also make them available at this same location. Or in January, when they do release the new forms, wherever you access your contract forms, you too have access to this document that outlines all of the changes. For the purposes of this class, I am not covering every single change. There's a lot of paragraph number changes, typographical errors, syntax changes, and a lot of changes to some documents or forms that I do not see widely used. And in the interest of time, they are not going to be specifically covered in this class. The forms highlighted today are going to be changes that GAR made for 2023 to the purchase and sale agreement, the all cash exhibit, conventional loan contingency exhibit, FHA and VA loans, the seller's property disclosure statement, condo state property disclosure statement, the dreaded community association disclosure. You guys, one small change, nothing major. Sale or lease contingency exhibit, backup. Oh, that's probably the biggest one. Wait till you guys see this. The backup agreement contingency exhibit, probably one of the most changed documents. But I think you listing agent, well, I think all of you are going to like it. So we'll see. I hope you'll be excited about that. We'll get to that after the break. Exclusive seller brokerage agreement. A couple of changes there. Nothing that changed on the buyer's brokerage agreement except for one minor thing. Temporary occupancy, I am going to cover that. Option agreement, I'm going to mention, but not go over in depth. Two new forms, addendum to the backup agreement and amendment to assign the agreement. So I'm going to talk about assignment, and I will talk about the backup agreement extensively. As you know, I don't know if I have it in the slide or not. Let me back up before I go on to this one. As you guys know, when the Georgia Association of Realtors makes a change to a contract form and that issue is addressed in more than one form, then those are what we call universal changes, meaning that change is made across forms. For example, if GAR made a change to the residential purchase and sale agreement, then that change is also changed in the commercial purchase and sale agreement, so forth and so on. So I don't pull out every single change that GAR made in all of those agreements, but there are universal changes when the same issue is addressed in multiple forms. You know what I mean. Additionally, for 2020 through 2023, GAR made changes to the new construction forms, the commercial forms. They added commission in the estimate of cost to buyer form. Option agreement is basically completely reorganized, and a lot of information has been added in there for clarification purposes. But as I mentioned, I do not see the option agreement used a lot, and there are other more widely used forms that I feel were more important to address in this class. There is an option agreement. This might come into play more in 2023. Option agreement to purchase leased property. In other words, if you're working with a public person and your public person ends up signing a lease with a seller to lease a house, and at this point, they are just going to be a tenant and just lease a house. This is not a lease purchase. It's just a strict lease, but they want the option to purchase it in the future. Then there is an agreement, option agreement to purchase lease property. While I'm here, just from an educational stance, because I can't help myself, this is a lease with an option to purchase at a later date. A lease purchase is a purchase agreement with an interim lease. So they're two separate agreements. Yes, Remind will release the changes too. Again, this form that I just showed you is a document, just like you access your purchase and sale agreement, you can access this also. All right, and then again, make sure to review the 2023 forms changes available wherever you access that. If we have time at the end of class, I will show you how you can access forms through Remind Docs Plus, for example, that you're not necessarily using in a transaction. There is also the form available, the changes that they made May 1st, 2022. All right, here we go. Let's dive in the purchase and sale agreement. GAR F201. Under the possession, under paragraph A4, this is a minor change, but apparently there were some issues over this. They changed the verbiage where possession, it used to say at closing, one of the options that possession of the property transferred to the buyer. In 2022, it said at closing or blank number of days after closing at a specific time. And you would use the temporary occupancy agreement. They changed it in 2023 to say upon closing. Why did they do that? Well, apparently that word at, the preposition at versus the preposition upon was interpreted that as of the closing date, the buyer got possession. But we all know sometimes a buyer and a seller will go to a closing attorney's office and will close a transaction, will sign all the paperwork. But if it is not funded by the lender, it is not officially closed. So the transaction in and of itself was not officially closed. So this change in preposition from at to upon implies that possession takes place once the transaction has funded and it is now belongs to the new owner, the buyer. Moving along under paragraph B, which are the explanatory paragraphs, the corresponding and explanatory paragraphs to the fill in the blanks in paragraphs A. Under the seller's contribution, they added the seller responsibility to pay off and handling the seller has to pay their own fees for the closing attorney to pay off their existing mortgage, and the buyer is responsible for their post-closing fees. So basically, there apparently were some sticking points. So okay, I'm getting a little tongue-tied, so let me catch my breath. Under the closing costs, when a buyer, in general, the closing costs that are required to close a transaction, and if a seller was making a contribution to a buyer's closing costs, then basically none of this has changed. The seller is helping the buyer with their closing costs, and it's based on what a lender can use towards closing costs. If the seller is is agreeing to contribute more and that the lender can use, it still goes back to the seller, and that's what it says here. Any unused portion goes back to the seller, and then it goes on. The seller shall pay the fees and costs of the closing attorney. Number one, to prepare and record title curative documents. In other words, if there's a cloud on title and there are fees associated with the closing attorney having to file deeds to cure the title, seller has to pay that because it's the seller's title. And for the seller not attending the closing in person, if the seller is doing a mail out, so to speak, the seller is responsible for the fees to the closing attorney regarding that. And then what they added is the seller is responsible to pay off any fees associated with the closing attorney, either wiring those fees to them, wiring those fees to another closing attorney for a back-to-back closing. Any fees associated with the payoff, the seller has to pay. Likewise, in 2023, under closing costs, items paid by the buyer, transfer tax, title search, so forth and so on, and they added all other title fees and post-closing fees. So the buyer is responsible for paying any fees the closing attorney charges, basically for recording deeds, and fees that are incurred after closing. Under the 8-day unilateral right to extend, they just added a sentence in here for clarification. So we know there are very, very specific reasons under which a buyer or seller may extend the contract for 8 days unilaterally, meaning only with one signature. This right to extend the contract unilaterally based on these reasons may still be utilized, including even after a financing contingency has expired. So apparently that got confusing because one of the reasons, two of the reasons that the 8-day unilateral extension could be used was if the mortgage lender had not had not finished their obligations and gotten the file out of underwriting, or if the mortgage lender had not sent the buyer their TRID disclosures within the federally regulated time frame of 3 days prior to closing. So the right to use this extension extends through day of closing, even after a financing contingency has expired. So they just added that because there's a lot of financing reasons. So just wanted to let you know they added that. They changed that for clarification. Just a couple notes on the 8-day unilateral extension. Again, it may only be used for reasons specified. You guys, a buyer and a seller may not exercise an 8-day unilateral extension because the house they're closing on, if they're doing a back-to-back closing, got delayed, or they can't get a mover. That is not a reason to extend the contract unilaterally. They could negotiate with the other party to extend it, but there's no, just for convenience reasons, you cannot extend it. The 8-day unilateral extension may only be used one time per transaction, not one time per side. That's always been the case. This is just, since we're here, just a reminder. Either party may use it for any of those reasons. So if you have a seller that wants to close with this buyer and the buyer's lender has not sent out the TRID disclosures, a seller may use the 8-day unilateral, sign and send the notice to extend the contract unilaterally for 8 days, even though it's a mortgage issue. Just want to let you know, you don't have to quote unquote stay on your side of the tracks. It's for those reasons, regardless of which side of the transaction your person is on. If, however, a lender delay, if the file is still in the mortgage company's underwriting department, but that delay is caused by the buyer, then you may not use the 8-day unilateral. And if the title issue, if there's an issue with the title, but it's due to a lien that a seller is required to pay off, you cannot use the unilateral extension. You would have to extend the contract by amendment. And yes, I see there is a question in the chat. May you still ask the seller to pay for closing costs? Yes, absolutely. That is an item to be negotiated between a buyer and a seller. All right. A couple of changes to the closing law firm representation, paragraph B5 in the purchase and sale. This has always been the case, but they are further clarifying this issue. Thank you, Georgia Association of Realtors. We appreciate this. So, pop quiz. Whom does the closing attorney represent? You guys type it in the chat. Who does the closing attorney represent? All right. Oh, I had one seller. Okay. Lender. Yes. That's if there's a loan involved. Now, nope, not the seller. Who does a closing attorney represent if there is no loan involved with respect to the GAR contract? No loan involved with respect to the GAR contract. Whom does the closing attorney represent? Broker, nope. Seller, by mixed bag. Whomever's paying closing, nope. Depends, nope. Okay, good. Okay, now I see why they clarified it. Nobody, nope, that's not it either. Title, note, yeah, well, yes, but not with respect to the contract. Self, that's always the case, Vern. Yes, follow the money. So, all right. Okay, this is going to be a little discussion. Whom does the closing attorney represent? Answer, follow the money. Lender, if there is a loan involved. Buyer, if there is no loan. Again, this is with respect to the GAR purchase and sale agreement. Now, I will let you know that it is Georgia law that in a contract for real property, it must be disclosed whom the closing attorney represents. That is Georgia law. That is above the GAR contracts. That is just Georgia law. That's why this statement is even in there. So follow the money. This is just a general way of thinking about it. If there is a loan involved, the closing attorney represents the lender because the lender is the main source of the money. If there is no loan involved in the GAR contract, it states that the closing attorney represents the buyer. Why? Because the buyer is the one that is providing the money for the purchase and sale agreement. Now, before I go on to the rest of this, I will let you know that even with respect to the Georgia law, where it says the closing attorney must disclose which party in a contract for real property, which party they are representing. Just because this is in the GAR contract, a closing attorney does not have to represent the buyer. For example, let's say there is a closing and the seller is a past client of the closing attorney, or the closing attorney has ongoing business or other business with the seller. The closing attorney in an all-cash deal may choose to represent the seller, not the buyer. If that is the case, per Georgia law, the closing attorney would have to disclose that in the closing documents. It doesn't have to be on the GAR contract. That is a disclosure that the closing attorney would make if the closing attorney chooses so. What happens if the seller is financing it? Great question. Yes, more than likely the closing attorney would represent the seller. But again, that is a disclosure between the closing attorney and the buyer and the seller that the closing attorney will make. But with respect to the GAR contract, what it's really important that you make sure your public buyer and public seller understand is when it says that the closing attorney, if there's no cash, if there's no loan, the closing attorney represents the buyer. But that does not mean that the closing attorney represents the parties if there's a dispute. No attorney is going to represent a public person in a dispute for no cost. It does not mean they've got legal representation in the sense of if you have to go in front of a judge or an arbitrator or a jury that you have an attorney that represents you. That is not what the term represent means with respect to this. It also, when it has that verbiage in the GAR contract, it does not mean that the closing attorney warrants the title in absence of any signed agreement specifying that it does. So what does that phrase mean? It means that the closing attorney is directed to prepare the documents and basically, prepare the documents, clear the title per title insurance standards, record the deeds, and issue title insurance. So prepare the documents. So let's think about this. If there's a loan, what is it that you get? What is it that as an agent, we always check with the closing attorney? Have you gotten the package? Have you gotten the package? Have you gotten the package? What is the package? In a loan, if a buyer's getting a mortgage loan, the package is a set of instructions to the closing attorney how to prepare the closing documentation. If there is no loan involved, the closing attorney does not get the set of instructions from the mortgage lender. So the closing attorney has to rely on the contract as the set of instructions. So in essence, basically what it means is the closing attorney prepares the closing documents with respect to what the buyer has said they are going to do to purchase this property. The amount, the sale price, the amount of the loan, the amount of closing costs that the seller is contributing, so forth and so on. Now, here in Georgia, we know that the closing attorney, that the closing documents basically represent both or reflect both the buyer and the seller's position with respect to the contract. But per legal terms, representation doesn't mean legal representation in a dispute. It just directs the closing attorney to do these issues. So let me read you how it actually reads. Yes, awesome. That's a great way of saying it. Protect the interest versus representation. Protect your interest, not really protect your interest, just prepare the documents with respect to the contract. So in 2022, it's the same. And then in 2023, they added this last sentence. And basically it says, in transactions where the buyer does not obtain mortgage financing, the closing attorney shall represent the buyer. That has been there. And then GAR is adding in next 2023. Represent the buyer in preparing the closing documents, attempting to clear title of the property to the satisfaction of the title insurance company. So that was one of y'all's answers in the chat. You are correct. Conduct the closing, dispersing the funds according to the settlement statement signed by the parties and the closing attorney, timely recording the deeds and issuing an owner's title insurance policy. Other than those services specifically listed above, nothing herein shall obligate the closing attorney to perform other legal services, meaning representing them in a civil dispute, including but not limited to certifying or warranting title of the property for the buyer, except pursuant to a separate engagement agreement signed by the closing attorney and the buyer. Again, this is just clarifying that the buyer does not have legal representation in a dispute, in a civil issue. All right, moving along. Under the inspection and due diligence period, they have added, they've tweaked this whole paragraph and just trying to impress upon the buyer, look, buyer, Georgia is a caveat emptor state. Buyer beware. The burden in the state of Georgia is on the buyer to make sure that the buyer is 100% satisfied with the property before going through with the closing. Georgia is a caveat emptor state, not only for real property, but for personal property too. The burden, the legal burden in the state of Georgia is for the buyer to make themselves 100% satisfied with goods or services they are purchasing before they exchange money for those. So in the GAR contract, with respect to how this is all spelled out under this paragraph B8 in the purchase and sale, this is what it used to read in 2022. And again, I covered the lead-based paint issue that was changed in May of last year. And this is how this set of paragraphs and subparagraphs was organized in 2022. And again, in 2023, you see at the bottom, I have 2022-23. It's just reorganized a little bit to hopefully be more clear and make more sense. So under first thing, it divides it into the buyer's right to inspect the property. And they've added verbiage that says the property is being sold in as is condition with any and all faults. Therefore, buyer and buyer's representative shall have the right to carefully inspect the property to make sure it meets the needs of the buyer. And then they put in bold print where the buyer may go and check out the government website to see if that property has been labeled as a meth house. Then they separated out buyer's right to inspect the neighborhood. And that's where it talks about the Georgia Violent Sex Offender Registry website, where a buyer may go and check out that property themselves, do their own due diligence. And then they separate out, none of this is a major content change. It's just reorganized to make it a little bit in an attempt to clarify that and impress upon the buyer the importance of doing these a thorough due diligence. That the buyer's inspection rights continue through closing. And it says upon notice to the seller. So you buyer's agents, your buyer does not have the right to access a property they have a contract on without notifying the seller. I mean, the seller still lives here. The buyer does not own it yet. So it does say prior notice to the seller. And this right extends through closing. That's so the buyer can do a walkthrough. And it goes on to further clarify buyer's rights to inspect the property with evaluations, surveys, appraisals, so forth and so on. And then it goes on, this is new verbiage in 2023, to confirm that any agreed upon repairs have been made. And it goes on to say where it addresses utilities, it says seller shall cause all utilities, systems, and equipment, so they've added that, to be on so that buyer may complete all inspections. Then they did add a new subparagraph under inspection and due diligence deed, buyer's inspection, indemnification, and obligations. Buyer agrees, this is all in bold. Usually when it's in bold, it impacts us as brokers and agents. Buyer agrees to hold seller and all brokers harmless from all claims, injuries, and damages related to the exercise of the above inspection rights by the buyer and buyer's representatives. And buyer shall promptly pay the seller the actual cost to restore any portion of the property that is damaged or disturbed from testing or other evaluations to a condition equal to or better than the condition it was prior to such testing or evaluations. We've all had horror stories where a buyer's inspector goes in and something happens through the course of inspection. They leave water flowing and it ruins the floors, or they do a septic inspection and it totally destroys the backyard or something like that. So that's what this is referring to, that the buyer agrees to not sue the seller or the broker and is responsible for repairing any damage or disturbance caused by their evaluation for their due diligence. All right, also lead-based paint hazard and evaluation. This has been in there, but it's just separated out in its own separate subparagraph. Lead-based paint hazard evaluation. Again, this is what's going to be in the 2023 GAR contract under the inspection and due diligence section. It again references if the property was built prior to 78, or if anything in the house was possibly painted prior to 1978. For example, you could have a modern home that has quote unquote reclaimed barnwood, or has an antique mantelpiece, or shiplap from an older house. So even if the property was built after 78, if there's any potential lead-based paint hazard within the property, you are required, you as the agent and the seller is required to have a lead-based paint exhibit and disclosure. That in GAR is 316, and you need to attach it. And the buyer shall have the right. These timeframes and these inspection, this is from the EPA. So this is not from GAR's thought process in and of itself. This is just GAR clarifying this and making sure that our buyers and sellers understand this from the EPA federal regulations. So it says conduct a lead hazard evaluation within 10 days from the binding agreement date or other mutually agreed upon time period, and to terminate the agreement without penalty, meaning a buyer would get their earnest money back upon notice to the seller if lead-based paint and or lead hazards are found, unless the right is waived. Again, this is not new verbiage. It's just teased out a little bit. This is verbiage that is pulled together from the seller's property disclosure statement and from other places in the previous version of the purchase and sale. Under due diligence period, again, this has always been the case. And if you've taken my classes, you have heard me repeatedly say that if there is a due diligence period, in essence, what that creates is a mini option contract between the buyer and the seller within the broader context of the purchase and sale agreement. And none of the rest of the purchase and sale agreement kicks in until this option contract has ended, until the end of due diligence. So GAR has just spelled that out. Under the due diligence period, it says if the property is being sold subject to a due diligence period, then A, this agreement shall be an option contract, during which time the buyer shall have the option for any or no reason to terminate upon notice to the seller, so forth and so on. And then it goes on to say, buyer shall accept the property in as-is condition, subject to any amendment to this agreement to address concerns as agreed to by the parties. So again, nothing new, just it's written out there for clarification and a talking point for you and your public buyer and public seller. Then under seller's duty to disclose, again, this is Georgia law. This is in there, has been in there in the seller's listing agreement, as well as in the property disclosure statement. They've just added this to the purchase and sale agreement here, that the seller shall disclose to the buyer any and all known latent or hidden defects in the property that could not be discovered by the buyer during a reasonably careful inspection of the property. In other words, if there is a big old huge water stain on the floor in the kitchen or on the drywall in the kitchen that you can readily see, a seller does not have to disclose that, because that is not hidden or latent. It could be readily discovered by a buyer during a reasonably careful inspection. Nothing changed under the warranties, and under repairs, they've added just a little bit more verbiage where it says, all agreed upon repairs and replacements shall be performed in good workmanlike manner prior to closing, unless otherwise agreed to in writing by the buyer and seller. So in other words, there could be a time when a buyer and a seller negotiate for any repairs or replacements to actually take place after closing. Or there could be a situation where a buyer is buying a property and they are totally going to renovate the property and change something. Nevertheless, there could be some agreed upon repair or replacement, either as negotiated between the buyer and seller in an amendment or as required by an appraiser. And it could be some sort of temporary fix, because the buyer is going to renovate anything anyway. So that's why, those are a couple of the reasons why GAR added unless otherwise agreed to in writing. All right, before I go on. So, okay, a couple questions in the chat. If the buyer damages the seller's property, will the buyer be responsible for the damage? Yes, absolutely. And that is not new. That has always been the case in the GAR purchase and sale agreement. What's new is that they hold the seller, they agree to not sue the seller or the broker. Now, just because it's in the GAR contract, it doesn't mean that a public person cannot sue. Anybody can sue anybody for anything. What this verbiage in the contract means is that the attorneys have a document that they can base their arguments on to say, look, buyer, you agreed to not sue the seller or not sue the broker due to that. You agreed to that. They can sue anyway, but it would be up to a judge and an attorney making that argument. And then another question, lead-based paint exhibit. Should you use it regardless if the property was, regardless of the year the property was built? That is an issue I will leave up to a discussion with your broker. During the foreclosure market, way back in 2008, a lot of the foreclosure sellers, banks, did include it in any and all documents. I know at Maximum One, Greater Atlanta Realtors, we do not require to use a lead-based paint disclosure with any and all documents, with any and all transactions, but that would be a question to discuss with your own broker. Another question, can a seller back out during due diligence? No, 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 no. A due diligence period is an option contract, but it's an option for whom? It is an option for a buyer to terminate for any or no reason. You guys, in your purchase and sale agreements, there are a lot of ways, a lot of contingencies under which a buyer may terminate and protect their earnest money. There are very, very few contingencies where a seller may terminate a purchase and sale agreement and not be held in default of the contract. All right, in the interest of time, let's move on. I want to get through, what time is it? Yep, we're good. Under the brokerage and agency part. Okay, the question is, one more question about that. What about if damage occurs after the due diligence period has ended? Yes, that obligation for the seller to hold this, for the buyer to hold the seller and the brokerage harmless and to repair the damage does exist, because as you will, let me go back and just show you that, why I'm saying that. You guys, your contract is nothing more than a set of instructions. So don't ever take my word for it. Don't ever take another broker's word for it. Don't ever take a closing attorney's word for what the contract says. There might be laws that overlay, but look to the contract and the instructions. A lot of these things are contractually driven and not Georgia law driven. But what about, the question in the chat is, what about if damage occurs after the due diligence period has ended? Well, number one, you will see that the buyer has the right to inspect the property, paragraph C, through closing. And then this is a separate paragraph, the indemnification obligations regarding not holding the broker and seller harmless with the above inspection rights. So this is through closing. This is the time from going under contract through closing. So great question. The due diligence period is not about checking out the property. Well, it is, but the due diligence period is about the buyer terminating the contract for any or no reason and protecting their earnest money. Okay, great questions, good class. Moving along. We have a lot of situations where there is one broker that is working with both sides of a transaction, working with both the buyer and the seller. So there is a lot of information regarding dual agency in the purchase and sale agreement. For Georgia license law, you as an agent and your brokers are held to license law regarding dual agency. Dual agency is legal, meaning the broker has a client relationship with the buyer and with the seller, as long as it is disclosed and your public buyer and public seller consent to it. So that's license law, and that's clearly disclosed in the GAR purchase and sale agreement, in the GAR brokerage agreement, so forth and so on. But we've had a lot of situations where a broker / agent have both sides of a deal, but it's not necessarily a dual agency situation. So GAR has added under the brokerage section reference to this situation. And it says under the agency disclosure, nothing has changed except for this last part sentence that they added. And it says no agency relationship. Buyer and seller acknowledge that A, if they are not represented by brokers in a client relationship, they are each solely responsible for protecting their own interests, and that broker's role is limited to performing ministerial acts for that party. And B, if, this is the new verbiage they added for 2023, if the same brokerage firm is representing one party as a client and working with the other party as a customer, the broker and all of the brokers affiliated licensees are representing the client. So that situation happens a lot. Let's say you're working with a public seller. They signed a seller brokerage agreement. You list it in the MLS services. You market it on the internet, and you get a sign call. That buyer, you ask the buyer if they're working with an agent and a broker. They're not. You show the buyer the house. They want to buy the house. As long as that buyer does not sign a buyer brokerage agreement, you are in a position to have both sides of the transaction. You are representing the seller as a client, and you can work with the buyer as a customer. Now, you need to check with your broker on your broker's policies. There are a lot of brokers that will not allow this. So just as a review, types of agency, single agency. In Georgia, the client relationship is contractually driven. What contract do they sign? The seller will sign a seller brokerage agreement and the buyer will sign a buyer brokerage agreement. Once they have signed that separate document, they are now a client of your broker. So single agency is public has signed a separate brokerage agreement with either the buyer or the seller. Dual agency, again, is legal in Georgia with disclosure and written consent, but check on your broker's policy. Dual agency is one broker and one agent. The broker has signed a client relationship with both the buyer and the seller, and only one agent is working with both sides. So in my example, you have a seller, they've signed this listing agreement, you put it on MLS services, you get a sign call, buyer comes and sees that property. They're like, nah, I don't really want to buy this property. And you say, great, guess what? I can show you any and all properties in the state of Georgia. And you sign a buyer brokerage agreement with that buyer to work with that buyer as a client. You show them other properties. The buyer comes back to you and says, you know, Dana, funny thing, remember that first house where we met? Well, I've decided that, you know what, I really do like that house and I want to buy that house. You are now in a situation where it's one broker, you as the sole agent, you are already in a client relationship with the seller, and you are also now in a client relationship with the buyer. That is dual agency. Again, at this point, you must disclose that to the parties, get written consent, and check with your broker. Your broker may not allow it, even though it is legally allowed. Designated agency, one broker, two agents. Broker has a client relationship with both the buyer and the seller, but there is a separate agent working with the buyer. So my same example, let's say that's a situation, you or your broker can designate another agent to work with that buyer client. So now the broker has quote unquote designated you to work with the seller. The seller's a client because they've signed a listing agreement, and the broker has quote unquote designated another agent in that firm to work with the buyer. Buyer is already a client because they've signed a buyer brokerage agreement with that broker. That's designated. And then as mentioned, you can have both sides not being dual agency, as I described earlier. It can be tricky, so please check your broker's policy. And I highly suggest instructor to agent, I don't care who holds your license, I highly suggest that you follow the steps with disclosure and consent, even if you are working with one side as a client and one side as a customer. I highly encourage you to follow the process and procedure and disclosures regarding dual agency, even if it is not dual agency, because nothing is an issue until it's an issue, but you will want to be able to demonstrate to a judge, to GREC, to GAR, to an arbitrator that you did thoroughly describe the situation and the parties upon information did choose to go on with that situation without bringing in any additional agent or broker. All right, you guys hang in there. We're going to finish the purchase and sale, and then we will take a break. So hang in there. All right. Brand new thing under the paragraph under C, other provisions. There is a, well, I don't have this in here. Okay, I know what it is. Under C4E, I'm sorry I didn't put a little cut and paste in there. They added a reference to special stipulation 661 regarding assignment by the buyer to another buyer. I'm going to cover this a little bit more in depth after the break because they have changed. That is one of the new forms is an assignment, but in essence, as a sneak peek, the GAR purchase and sale agreement may not be assigned. A buyer who is binding under GAR purchase and sale agreement may not assign the contract to another buyer, which is a strategy a lot of investors use, without the seller's written permission. GAR created a special stipulation, which again, I'll address at the end of this class, that you can put, you buyer's agents working with investors, you can add this special stipulation into your purchase and sale agreement that does, where the seller does give written permission for the buyer to assign the contract. So that's been in there. They just reference the actual special stipulation number for convenience purposes for you guys as agents. Then paragraph C4G, brand new in 2023. It is the FIRPTA affidavit. And what that stands for is the Foreign Investment in Real Property Tax Act. And basically what this says, well, again, not basically, but specifically what this says, unless the seller is a quote unquote foreign person, as that term is defined in section 1445F3 of the Internal Revenue Code. Again, you guys follow the money. This really has to do with taxation and money that would go to the IRS and to the state of Georgia. But for FIRPTA affidavit, unless seller is a foreign person, as that term is defined in section 1445F3 of the Internal Revenue Code, the seller shall deliver to the closing attorney at closing a FIRPTA, or Foreign Investment in Real Property Tax Act affidavit, indicating that the seller is not a foreign person. If the seller is a foreign person, and I'm using quotation marks because that is specifically defined in the Internal Revenue Code section, if the seller is a foreign person, additional taxes may need to be withheld at closing. For further information on that, you need to check with the closing attorney that is closing the transaction and what, if any, additional taxes will be collected by the closing attorney. Moving along, in the survival paragraph, they added another issue that survives closing. Survives closing mean the party's legal obligation with respect to this is still legally intact even after the closing of the transaction. So it is always said the following shall survive the closing of the agreement. 1, the obligation of a party to pay real estate commission. Yay! 2, any warranty of title. 3, all written representations of the seller in this agreement regarding the property or neighborhood in which the property is located. Those items have always been there. Not always, but last year. Number 4 is brand new for 2023. Buyer's indemnification obligations arising out of the inspection of the property by the buyer and the buyer's representatives. That harkens back to what we just talked about in the new paragraph under the due diligence and inspection paragraph. In other words, even after the property closes, the buyer still is obligated when they sign this contract to indemnify the seller and the brokers regarding of any damage caused throughout the inspection process. That's the new thing. And then 5 has been in there last year, section on condemnation. 6 has been in there, a section on attorney's fees. 7 has been in there, obligations of the parties regarding ad valorem real property taxes. And 8 has been in there, any obligations which the parties herein agree shall survive closing or may be performed or fulfilled after the closing. All right. That's it for the purchase and sale agreement. So the next item will be the all cash exhibit, and we will go on for the rest. But let's do this. Let's take a break, and then we will knock out the rest later. So, all right, welcome back, everybody. I hope you are enjoying the class so far. Not a ton of changes, but I think, again, as GAR always tries to do, more clarification changes for purposes of the public as well as for co-op agents to help you guys. It's not necessarily for a co-op agent where they may not know it, but it's just a talking point to help you as an agent have this discussion and bring up these issues with your public people. So we are going to continue on. That's it for purchase and sale. we are now going to tackle the financing exhibits and the rest. So I'm going to go back and share my screen. And we're going to go back to the PowerPoint. All right. All right. Moving right along. All cash exhibit. GAR's actually made quite a few changes to this one. And again, a lot of this is in reflection of this very competitive market that we have been in. So it is now called the no financing exhibit. It used to be called the all cash, and then in parentheses had no financing exhibit. And now they have changed it, and it is just now called the no financing exhibit. And GAR has modified this in an attempt to avoid the bait and switch. Okay, Dana, what do you mean by bait and switch? Again, in this highly competitive market where our sellers were getting multiple offers, there were a lot of offers that they were getting from buyers where the buyer would portray themselves as being an all cash deal. And in essence, they were still getting a mortgage. And a seller would choose that contract being led to believe it was all cash when it wasn't. So they've changed this exhibit up just, well, number one, if you're a listing agent and you get an offer with nothing referencing financing, you should counter back with asking for this exhibit. But regardless, they've changed this exhibit just a little bit to try and really portray accuracy as to the buyer's source of funds. So under method of purchase, it used to say all cash sale. Now they've changed it to, again, make it a little bit more descriptive so everybody's on the same page and everybody knows the source of the funds. So under method of purchase, it says A, all cash purchase. Buyer has sufficient liquid assets to purchase the property in this transaction for, quote, all cash. The buyer has no right to unilaterally extend the closing date for 8 days for a reason of a mortgage lender delay. Notwithstanding the above, the buyer shall have the right to extend the closing date for 8 days if the closing attorney is not ready, except if the basis of the closing attorney to not be ready is due to or related to a mortgage lender delay. Or under method of purchase, B, finance purchase with no financing contingency. In other words, the buyer's getting a loan, but they're willing to, quote unquote, risk their earnest money. They're not making the deal contingent upon them getting that loan. They're confident they're going to get it, but they're still disclosing to the seller that they are still going through the mortgage process. So it says buyer intends to obtain mortgage financing to pay for all or portion of the sales price of the property, provided, however, this agreement shall not be subject to a financing contingency. Even though buyer is obtaining a mortgage loan, the buyer has no right to unilaterally extend the closing date for 8 days for reasons of the mortgage lender delay. Notwithstanding the above, buyer shall have the right to extend the closing date for 8 days if the closing attorney is not ready, as long as the basis for the closing attorney to not be ready is not due to or related to the mortgage lender delay. So the question is, if you agents are working with a buyer getting a hard money loan, you would choose this option B, finance purchase with no financing contingency. That's any type of mortgage loan, whether it be from an institutional mortgage lender or a short-term loan for a hard money lender. So again, in 2022, it just had all cash sale. And then it specifically said obtaining mortgage from non-institutional first mortgage or no right. So the changes in 2023 are for clarification. Then continuing on with this exhibit in 2023 under the second, yeah, I think it's a good change too. I think it's just getting everybody on the same page so that buyers and sellers may make informed consented decisions throughout the negotiations. And there's no bait and switch, so to speak. Okay, under paragraph 2, where it says verification of funds, it does say at the bottom was the, well, it does say, I'm sorry, I'm getting all tongue-tied. It does say for 2023, they've added to this. Within blank number of days from binding agreement date, buyers shall be obligated to provide or cause to be provided to seller. That's the phrase they added. Information describing the source of the funds necessary to purchase the property. So they've added that. And then they have also added, whenever they reference the funds in paragraph A and B, they've added the phrase in US dollars. So the bottom where I have down here at the bottom, that was the 2022 version. What I have typed up in bigger letters is the 2023 version. So they've added provide or cause to be provided, and they've added US dollars. And then under C, they've added if option 1B is selected above. So again, option 1B is this option. If they are using a mortgage lender, they're just not making the transaction contingent upon that. But if they are getting a loan, whether it be from a hard money lender or an institutional lender, then they are required to also provide a loan commitment letter from that mortgage lender. So again, I think these are good changes to the cash exhibit. And again, it's now called the no financing exhibit. Okay. I think y'all are going to like this too. Under the conventional loan contingency exhibit. And again, this is a universal, wonder if they're going to change to address cryptocurrency. Probably not. I'm assuming not, but they did, because they did add in US dollars. Okay, under conventional loan contingency exhibit. And again, this is a universal change that is changed throughout all the loan exhibits that address loans. So it is under the part where it says interest rate. They've added the word at par, and they've added not greater than blank % per annum. So at par is the interest rate that a lender is willing to lend money without a buyer, quote unquote, paying money to buy the rate down, without a buy down or paying points. So that's the interest rate as quoted by the mortgage lender with no money to buy it down. And the interest rate, again, not greater than, especially in this climate of rapidly changing interest rates up and down every week, they've just added that in all of the financing exhibits. Okay, now some other changes that they have made. Again, you guys, this is not, there's not a lot of substantial changes. They've just reorganized these loan exhibits, especially regarding the timeframes and the fill in the blanks. So they've added a whole new paragraph, and it's a paragraph separate from the financing contingency and separate from the appraisal contingency. And it is a standalone paragraph with a fill in the blank for the time frame. And it states length of financing contingency period. The length of the financing contingency period in section 6 below shall be blank days from the binding agreement date. So before, in 2022, the time frame of this financing contingency period was spelled out under the description of what a financing contingency is. Now the time frame is a separate fill in the blank. And also in the appraisal, where it references the appraisal contingency, they also have referenced the time frame, the time period for the buyer to request a reduction in the sale price of the property if it appraises for less than the purchase price of the property as set forth in section 13 below shall be blank number of days. So in other words, what they have done is they have teased out the time frame for these contingency periods, and then there's a whole separate paragraph that describes what the contingency is, what the obligations are, and how the parties go about negotiating through issues if the property regarding the financing contingency and the appraisal contingency. And I apologize again, at the time of teaching this class, I do not have an actual copy of a training version of the conventional loan contingency exhibit. I do have the VA loan contingency exhibit, so I'll show you that. But nevertheless, these are the changes. It is a little bit tricky to see out of context. But if you keep checking back that site, as soon as I get them, I will post them. Now, moving on, again, here's what it says. I don't have the exhibit as a whole, but I do have what the contract says. So basically the language describing it is clarified. In addition to removing the time frame and putting it in a separate paragraph, it is further clarified. So in 2023, the parts that I have underlined in red is what is going to be additional. No, the FHA and VA, yes, very similar, but I'm going to cover those in just a second separately. This is the conventional. Under the financing contingency, it says buyers shall have a financing contingency period equal to the number of days set forth in section 3 above to determine if the buyer has the ability to obtain the loan described in the financing contingency period. And then all the rest of this is the same, where it says buyers shall be deemed to have the ability to obtain loan unless prior to the end of the financing contingency period, the buyer notifies the seller that they're terminating because the buyer's been turned down for the loan, and provides the seller within 7 days of the notice the loan denial letter. So in other words, a buyer and a seller negotiate. The seller says, okay, buyer, I'll give you X number of days to convince a lender to lend you the money. If not, you have to send me a notice of termination prior to that time frame, and you have to prove it with the loan denial letter. Now, the loan denial letter has to be, there's certain specifications what can be included in that for a buyer's earnest money to be protected under this contingency. And it says the loan denial letter and mortgage lender issuing the loan denial letter must meet all of the requirements set forth elsewhere in this exhibit, but may be provided to the seller after the financing contingency period has ended if the above referenced 7-day period to provide the loan denial letter falls outside of the financing contingency period. Notwithstanding the above, the end of the financing contingency period shall not limit the buyer's rights under the appraisal contingency section set forth in this agreement, provided the same is not expired. Basically, the time frame is the time frame within which the buyer needs to send the notice of termination to the seller. The buyer can then prove it with the loan denial letter from 7 days from the date of that notice, even if that 7 days is outside of this negotiated time frame. Also, just as a note, the financing contingency and appraisal contingencies, you guys, these are completely separate issues, even though they are addressed in GAR on the same exhibit. A financing contingency is the lender's assessment of the buyer's ability to pay back the loan. A lender looks at the buyer, how much money they have out, their repayment history, their credit score. Do I think that this person is going to pay me back the hundreds of thousands of dollars, tens of thousands of dollars I'm going to loan them? The appraisal contingency is if I made a bad decision, if I decided that this person was a good risk, but I made a bad decision and I got fooled or whatever, or something happened, and the buyer is not able to pay me back, then what the buyer put up for collateral for that loan, the house, is that, can I turn around and sell that and recoup the money that I lent? So if the appraisal contingency is an assessment of the property or the collateral, a financing contingency is an assessment of the risk of the buyer. So under appraisal contingency, if the lender made a bad decision on lending the money, then this is an assessment of the collateral, if the collateral is valuable enough to pay back the lender what he lost in exercising bad judgment with the buyer. So two separate things being evaluated here. Now, in 2021, again, nothing has changed except the time frame for the contingency has been teased out into a separate paragraph. So moving on to FHA and VA, those changes are the same in terms of the financing contingency is separated out into a separate paragraph. However, it's a little different because, as I mentioned at the beginning of class, if a buyer is getting an FHA insured loan or a VA insured loan, in essence, the appraisal contingency is addressed in the amendatory clause paragraph, and those protections for a buyer's earnest money is protected through date of closing. So there is no time frame for an appraisal contingency if the buyer's getting an FHA or VA insured loan. FHA and VA insured buyers' earnest money is protected on a low appraisal per the amendatory clause, federal regulation. The amendatory clause prevails regardless of any special stipulation in the contract or amendment. Again, you listing agents, don't be tricked by an appraisal gap stipulation if the buyer's getting a government insured loan. That stip is not enforceable. So on the FHA loan contingency exhibit, again, the same change to the interest rate where it says at par and an interest rate not greater than, and the new paragraph regarding length of financing contingency is the same. The only difference is, again, because there's no time frame for an appraisal contingency, they've changed a little bit. Okay, this is all the same as it was in the conventional. And in 2023, under the amendatory clause, because they've added that new paragraph, it's no longer paragraph 11, it's now paragraph 12. And it states, this is the same, this first part is the same. What they have added here at the end is if the written statement by the Federal Housing Commissioner or direct endorsement lender sets, I have it spelled wrong, sets forth an appraised value of the property that is less than the minimum appraised value set forth in this amendatory clause, the seller may reduce the purchase price to an amount equal to such actual appraised value, and the parties shall close as such lower purchase price with the appropriate adjustments to the sales agreement. And then this clause shall apply. In other words, FHA VA loan, if the appraisal comes in lower than contract sale price, but the seller agrees to sell it at that lower price, at that point, the buyer is obligated to go through with the purchase. Yes, there is a question in the chat. The appraisal gap does not apply to FHA and VA loan. Yes, even if it's in the contract, it is not enforceable. A buyer's earnest money is protected on a low appraisal if the buyer is getting an FHA or VA insured loan, provided that the buyer send notice of termination based on the low appraisal before closing date. That's always been the case. That's not new. All right. Now, moving on with other changes to the FHA loan contingency exhibit under the repair section. Basically, this has been the case. This repair issue has been tweaked over the past few years. And this has always been the case. They just added this verbiage for clarification. Basically, buyer and seller negotiate that if the FHA appraiser mandates repairs, either the buyer or the seller will pay for the repairs as long as they do not exceed whatever amount dollar got negotiated at time of going under contract. However, if the FHA, or this is true in VA too, if the FHA or VA lender mandates repairs and those repair costs are more than the amount that were originally negotiated between the buyer and the seller is required to go get a contractor, get estimates for the amount of the repairs. Buyer and seller negotiate who is going to pay the overage over what was initially agreed upon. If they cannot agree upon that, the contract automatically terminates. And what was added for 2023 is without penalty to the buyer. That was always the intent of GAR. It was just specifically spelled out that if you can't agree, the contract terminates and the buyer will get their earnest money back. None of the rest of this has changed. Moving on to the VA loan contingency exhibit. Same changes as FHA in convention with the interest rate, financing contingency, and mandatory clause, and the repair costs. What got changed with the VA is the termite paragraph. This poor termite paragraph has been changed and addressed and tweaked for several years by the Georgia Association of Realtors Contracts Committee, Forms Committee. So basically, this is how it's going to read in 2023. And again, what I have underlined in red are the changes for next year. VA rules and regulations termite letter. an official Georgia wood infestation report, quote, termite report, meeting the requirements of Georgia law and dated within 90 days prior to closing, indicating that the property is free of infestation from termites and other wood destroying organisms, shall be obtained by and at the sole expense of buyer or seller. You guys love that. There was always some issue regarding, especially in this competitive market, who was paying for that. So there's now an option, y'all. Don't miss that. You need to negotiate who is paying for this termite clearance letter. And then the rest of that goes on regarding the notice of value and termites. But it goes on to say basically, it goes on, they've added this other verbiage that any reinspection fee necessitated by the seller correcting infestation with termites and or other wood destroying organisms shall be paid for by the seller. So if the VA appraiser determines that there is damage caused by termites, either current damage or previous damage, and they do mandate that that damage be fixed, and then the termite company has to come out there to issue a clear letter and indicate that that reinspection, that new letter, that additional letter is to be paid for by the seller. So let me get out of this PowerPoint just for 1 second. Let me show you guys what the VA exhibit looks like for 2023. This is the 2023 version. This is going to be what the other exhibits look like as well. This is where it says interest rate at par, not greater than. This is all the same. This is the new paragraph where it talks about length of financing contingency period with the fill in the blank. This is the same. This is the same. This paragraph under financing contingency, this just explains what the financing contingency is and what the obligations and forms of notice and proof is. They just took out the fill in the blank for the time frame, but this is, they've added that we've talked about in the PowerPoint. The use of the approved mortgage lender, loan denial letter, nothing in that has changed. Right of seller to request evidence of buyer's ability to close. That's the same. Seller's right to terminate if this isn't done. That's the same. Authorization for the lender to release information to the seller. That's the same. That's the same. A mandatory clause. We've already addressed that. The VA funding fee is the same. Certain repairs paid for by the seller is the same, except for what I just addressed. The termite letter, that's what I just went over. All the rest of that is the same. So I just wanted to show you that it's not drastically different. The basic difference that's going to catch you unawares if you're not expecting it is the time frame is teased out into a completely separate section. All right, back to the PowerPoint. And USDA loan is the same as we've already talked about. All right, whew, not too bad, right? Moving along, seller's property disclosure statement. Again, no major changes to this, except under paragraph D, the fixtures checklist. This is the same, so I didn't retype it, but basically they've added this one section that says, this is where, you guys know, this is where the buyer and seller negotiate what items the seller is leaving with the property and what items the seller is taking with them and when they close on the property. They've added this. Once the seller's property is under contract, the items that may be removed and taken by the seller, as reflected in the seller's property disclosure statement, may only be amended with written consent of the buyer of the property. Honestly, I'm not quite sure why GAR added that in, because any changes to a contract have to be done by amendment, and on an amendment, it requires buyer's signature, meaning their consent anyway. So I'm not exactly sure why they felt the need to put that in there. Typically, it's a reflection of a lot of issues that they had the previous year, but an amendment needs buyer and seller signatures anyway. But anyway, nevertheless, they have added that in to the seller's property disclosure statement exhibit. The same verbiage is also added into that new form, the shortened seller's property disclosure statement, where it's basically the seller's affidavit of latent material defects. Now, under the condo seller's property disclosure statement for a condo, If you do sell condominiums, whether you're on the listing side or the buyer side, please note there is a completely separate property disclosure form for a seller to complete. In that form, F304, GAR has added 2 new questions. Under the general section, it asks what year was the building in which the unit is located originally built, and what year was the declaration of condominium first recorded. And then it also added, or basically reworded, if it's a condo conversion, what year was it converted? So again, if you're selling condos, make sure you're aware of that. Okay, the dreaded community association disclosure exhibit. No major changes other than adding additional information under the type of association. So for 2023, all that they added under the checkbox where the seller indicates the type of association, they've added it's a voluntary association transitioning to mandatory, and buyers shall be a voluntary or a mandatory member. So they've added that as an option under the type of association. That's it. That's the only change to the community association disclosure. So we're happy about that. Sale or lease of buyer's property contingency exhibit. All right. Again, nothing major. This got majorly changed in 2021, tweaked a little bit in 2022. In 2023, they just added one more sentence because it basically, this form now gives a seller, if a seller is going to accept a contract from a buyer, but the buyer is making their contract to purchase the new home contingent upon them selling their existing home, this gives the seller a lot more information / control over what the buyer does with their existing home in order to sell that to buy the new home. And again, a lot of that was changed majorly in 2021 and 2022. But part of that was buyer, that it is contingent upon the buyer closing on the sale of their other property. And if it's not already under contract, the buyer shall keep other property listing for sale with the real estate broker at a list price of not more than X amount of dollars until it's either sold or closed or the contingency period expires. Because they referenced a specific list price for the buyer for their current home, they added the verbiage, nothing herein shall give the buyer an ability to terminate this agreement if the property sells for an amount greater than the list price. Honestly, I'm not sure why they use the term greater than the list price rather than different from the list price, because I believe the intent is if a buyer buying a new home makes their contract contingent upon them selling their existing home. If they sell their existing home at anything other than the list price, even if it's lower, that does not give them the right to terminate this contingency. So again, my question is, why did they added this phrase, why did they use for an amount greater than list price rather than just different? I don't know the answer to that. I'm just putting it out there. Backup agreement contingency. Lots and lots and lots of changes. But I think you guys might like them. They've made the changes to reference more than one backup. So before I go any further, prior to 2023, and if you guys have been in my classes, y'all have heard me say this many, many, many times. You are working with a buyer. You call an agent working with a seller. They will say, you call for availability to find out what's going on with the property. The listing agent will say, we're under contract and I've got several backups. Prior to 2023, that's just not true. They could have a lot of other interested offers, but they could only have one binding backup agreement. Why? because the backup contingency referenced the primary buyer, and it only had a place to reference one buyer, the buyer that was under contract with the seller. Again, in response to this hyper-competitive market that we have been in, and in response to sort of how agents communicated with one another, they have now totally revamped this form to account for a seller being able to have more than one binding backup contract. So let's see what they have done. In 2023, paragraph 1 states, buyer and seller acknowledge that this agreement is a backup agreement in, and there's a fill in the blank. You're going to put first place, second place, third place, fourth place behind the primary agreement with the binding agreement date that's supposed to be date of, and that's the date of the binding agreement of the primary contract. Okay. Buyer and seller acknowledge that this agreement is a backup agreement in first, second, third, fourth place behind the primary agreement with the binding agreement date of blank for the purchase and sale of the property between the seller and the primary buyer as identified, and that's the last name of the primary buyer or authorized signatory, represented by or working with, and you fill in the name of the broker, the primary buyer's broker. And that backup buyer has no right to purchase the property unless the primary agreement and other higher priority backup agreements, if any, and which are more specifically identified on an addendum to backup contingency exhibit F605 attached hereto and incorporated herein, are terminated, and seller gives notice to the buyer. Whew, there's a lot there. Basically, what this is saying is there are more than one position for a backup buyer. If this buyer is in second, third, fourth position, this does not become primary agreement until those other higher agreements terminate and the seller gives notice of that. This does reference this backup addendum to backup contingency exhibit F605, which is a brand new form for 2023 that I will show you in a minute. Yes, you are. There's a question in the chat. Are we releasing the buyer's name and buyer's broker from the primary contract? Absolutely. That was the case in 2022 also. That was always on the, that's in 2022, you have to identify the primary buyer in the backup contingency exhibit. So that's not a change. And here's where it is in 2022. Buyer and seller acknowledge this is a backup or secondary agreement with the binding agreement date of between the buyer and blank. You identify the primary buyer. So that's not a change. It's just the hierarchy of backups. Then so basically, because there's now more than one backup agreement in everything where they reference primary contract, they now have to take into account that there can be more than one backup. So in 2023, under the termination part, it talks about a higher backup. So it says, before it said upon closing up with the primary agreement, this agreement shall terminate and buyer gets their earnest money back. Now it says upon closing of the sale of the primary agreement or backup agreement in a higher position, this agreement shall terminate, buyer shall be entitled to refund of the earnest money. Same thing in all of the paragraphs under paragraph 3 and 4. Here's where it is, what it said in 2022, and nothing content-wise or conceptually has changed. It's just a reference to anything having to do with a primary backup agreement or backup agreements in a higher position. In other words, if the primary agreement or backups in a higher position are amended, it doesn't affect this one. And the buyer does not have the right to see any of the other contracts that are ahead of them. And again, it states after primary agreement, new language added, and all other backup agreements. Again, it's just referencing that every time it mentions primary agreement. So this is the brand new form. Addendum to backup agreement, F605. If you listing agents, if you have a seller under contract with the primary buyer, and then you have more than one backup contract, you must use this brand new form, addendum, that identifies the hierarchy of each backup. And what it says, this addendum is part of the backup agreement contingency exhibit, and you fill in whatever letter of the agreement with an offer date of blank for the purchase and sale of certain property known as, and whatever the address is. So you identify all of the backups with buyer name and broker representing that buyer. So this is what it says. The following backup agreements are in higher position than this backup agreement. The primary backup agreement has a binding agreement date of blank for the purchase and sale of property between seller and primary buyer identified as, and you put in the last name of the primary buyer, represented by or working with, and you put that buyer's broker. The second backup agreement has a binding agreement date of blank for the purchase and sale between the seller and the second buyer identified as, last name of the second buyer, and the broker representing that buyer in second backup position. The third backup agreement, you identify that with the binding agreement date, the last name of the third buyer, and the broker representing the third buyer. And then the fourth backup agreement, same thing. You identify the hierarchy of the backups by binding agreement date, last name of the buyer, and the broker representing that buyer. Where it says authorized signatory, that's in there because if there is, for example, an LLC that is purchasing the property, it could be the name of the person within that company that has signing authority. All right, so now let me look at the questions. Do you have to, okay. Is the binding agreement date for the primary buyer or as a contingent buyer? The binding agreement date is it depends on which one you're looking at. So let's go back and look at this one. This one, you're referencing the binding agreement date of the primary contract. The seller goes under contract, they're under contract. That's the one they're intending to close with. This under the backup contingency exhibit, under paragraph 1, you're identifying the binding agreement date of the primary contract. In this addendum, you're identifying the binding agreement date that you went binding as a backup. So that's the question. That's the answer to that. Do you have to notify any of the subsequent backups that there are other backups, if there are any? So no, you do not need to, let me think about that. That's a good question. I don't think there is an obligation to notify the backup offers in higher order of anything behind them. If you are a lower, I'm sorry, this should say fourth down there. I didn't correct that. If you are in a lower position, lower down in the hierarchy, you have to let them know there are others above them. But I don't think there is an obligation to identify, like you don't have to let the primary buyer know that there are backups. You agents working with buyers, this is a competitive market. Your buyers should always negotiate as if the seller has other options, because the seller, even if there's not a binding backup, the seller can go back on the contract go back on the market as active and get another contract. All right, once ordered, first, second, third, can you reorder them if one of the backups makes a stronger offer to become higher? Okay, so at that point in time, no, you are already going to be, you're already going to be under contract with the primary buyer. These other contracts, you guys, you're going to your sellers and backup buyers are going to fully negotiate a contract, sign everything. You're going to have a binding contract. So once you have a binding contract with a backup exhibit, you can't terminate it unless both parties mutually terminate. So there's no renegotiation. Once it becomes a binding backup, not just another interested offer, but once it becomes a binding backup, that's the position it's in. If you already have a primary buyer and you negotiate with another buyer and you go binding as a backup, that is now the second buyer's broker. The third, that would be if you get a third interested buyer, even if their sale price is higher than buyer number two, you have to go through, a seller can't terminate a binding contract because they got a better offer. The seller would default on that second backup offer unless there's a mutual termination. So buyer number three, even if it's a higher offer, if you're going binding as a backup, would still be in third position. So great question. These are binding contracts you're dealing with. So the same rules of termination apply. But good question. Who receives this addendum? All parties or only the primary? The actual seller gets a copy of this because the seller is going to be the one to sign it, and whomever this is going to. So for example, let's say the seller is under contract with the primary buyer. They have a second buyer. They negotiate a contract with the second buyer. At that point, this document is an addendum to the second buyer's contract. Then if they get another interested buyer and fully negotiate another third contract using the backup contingency exhibit with a third buyer, then you would fill in primary buyer, secondary buyer, and this addendum is attached to that third buyer's contract. The seller's agent fills out this form. Yes, because the seller's agent is going to be the one that knows the information that can identify the other backup contracts. All right, let's see what else. It reads, yes, it should be date of. I'm sorry, I had to type this one out because I didn't have a copy of it. So that's just a typo on my behalf. Yes, you can now, well, you've always been able to accept one backup. Now, yes, a seller may accept more than one backup agreement, may fully negotiate. If you found your buyer another house, can you renounce the backup? Yes, and that is all, none of that has changed. Does the earnest money deposit? Okay. You guys, the rest of the backup contingency exhibit has not changed. And I don't have that pulled up, but basically a buyer that is in a binding backup contract may terminate the backup contract under no penalty, get the earnest money back and go find something else. None of that has changed. So even if you are in second, third, fourth position, that buyer may always terminate the backup contract before being notified that they are primary and their earnest money is protected. Does earnest money, yes, earnest money, great question, Kim. Earnest money, and this is all spelled out. Let me see. Earnest money is deposited, is sent to the holder at the time these backup buyers sign a binding contract. It's no different than any other binding contract other than they are in backup position. So all the other terms of the backup contingency exhibit are in play. The only change is there can be more than one backup now. Another question, does the third buyer see the other higher buyers? No, nobody, none of the other buyers are entitled to see any other contracts. They are just notified that there is another backup contract ahead of them. And it's just identified by binding agreement date, last name of buyer, and broker of that buyer. But nothing else is revealed to any of these other buyers. No price, no terms, nothing. Oops. Let me look at these other questions. Some sellers will ask to disclose the amount of the offer or backup offers. In such case, the backup offers may wish to increase their offer, move up. Great question. I have handled this. I have a YouTube video, YouTube channel called Real Estate Made Crystal Clear. I have 4 or 5 years of contract tips on there. It is open to any and all agents in the state of Georgia. And I have addressed this in a video, but I will address it here. You as a listing agent, you are allowed to reveal information about even an offer, even if you're negotiating an offer, to other buyers, as long as you have seller's written permission and there is no discrimination that gets, or no intent to discriminate, or nothing that can be led as discriminatory in that revelation regarding what the other competing offers or binding contracts are. You cannot identify like social security numbers or you can't do anything for identity theft. You can't reveal that kind of stuff, but you do have to have your seller, and you can't be misleading to anybody, but you do have to have your seller's written permission, and check with your broker. All parties having contract information. Okay, I just addressed that too. Check with your broker's policy. You need to have your seller's written permission, and you cannot reveal anything that would be potentially interpreted as discriminatory or misleading. Woo! All right. All right, moving along. You guys check out the backup contingency exhibit. It's beyond the scope of this class, and I've got other things to cover. But if you will pull up the backup contingency exhibit, you will see all the other things that do fall into place regarding being a backup contract. Okay, seller's brokerage agreement. Okay, that's it for all that stuff. Now, moving on, seller's brokerage agreement, F101. They've again teased out some information regarding lead-based paint, and it basically says federal law requires disclosure of lead-based paint in homes or properties, or even if a portion thereof was constructed prior to 78. I've already addressed this at the beginning. Or if you have something like an antique mantelpiece, reclaimed barnwood, shiplap from an older house, so forth and so on. This is a new paragraph. This whole paragraph 7, it's the same information. It's just more in your face for our public, so that they just understand their rights. A dwelling on the property or portion thereof was constructed prior to 1978. Seller agrees to complete and provide broker with a signed lead-based paint disclosure exhibit F316 at the time of signing of this agreement. Again, this is the listing agreement or the seller brokerage agreement, and is attached as an exhibit. Or B, no dwelling of the property or portion thereof was constructed prior to 78. Lead-based paint disclosures. Again, the EPA is a government federal agency. The federal law requires that before being obligated under a contract to buy a house built prior to 78, buyer must receive the following forms from the home seller: the lead-based paint pamphlet and the lead-based paint disclosure. GAR has them available. You can get them from EPA.gov. You can get them from the Georgia Department of Community Affairs. You can get them from the RE Forms contract. There are lots of places to get this information. They are referenced here. GAR has CB04, lead-based paint pamphlet. Protect yourself when buying a home. Disclosure information concerning lead upon transfer of residential property. And the seller must disclose any knowledge of lead-based paint with the exhibit. There's a separate exhibit for leases. The seller must sign and make these available to prospective buyer prior to entering a contract. So you listing agents, you need to get your sellers to sign this at the time you sign the listing agreement, and do not leave the house without getting that signed and completed by the seller. Seller also must allow the buyer, if desired, to do a 10-day risk assessment of the lead-based paint. Here are some resources for you guys: EPA.gov, There is a whole separate agency, the Georgia Environmental Protection Division, that has information about lead-based paint and how to abate that, as well as the Georgia Department of Community Affairs. And lead-based paint is a huge issue. Make sure to protect yourself, protect your sellers, and protect your buyers. Okay, another new section in the listing agreement regarding images. Basically, we are disclosing to sellers. Look, seller, once you put your house on the market and people are coming into your home, they may take pictures and they may take videos. If there is something in this house you do not want out there, you have a responsibility to move it. So this is a new subparagraph under B3, and it says, seller agrees to remove any personal property prior to listing the property of which the seller does not want images to be so captured. The broker shall not be liable to the seller if other brokers or buyers take photographs, videos, or use other technology to capture and manipulate images of the property without the permission of the seller and the broker. So you listing agents, in the listing agreement, you have permission to take photos and video of the interior of the house. You buyer's agents, when you are previewing a house or working with a buyer, you do not have a seller specific permission to take photos or videos. Does it happen? Yes, of course it happens. So this is a disclosure to the seller. Dude, if you've got a priceless autographed baseball by Babe Ruth, take it away so that nobody can see that when your house goes, when pictures of your house inadvertently get spread all over the internet. Now, you buyer's agents, this is not disclosed anywhere. This is just a point of practice. When you are showing a home, just know the sellers also more than likely have recording devices in their homes. You are probably being audio recorded and video recorded when you are in that home. Be professional. Do not have any disparaging remarks about the seller, about the seller's taste, or about the property. Number one, it could damage your client's position with respect to a contract. And number two, you are more than likely being recorded. Just keep that in mind. Now, what about license law? May an agent take pictures or video to market another's listing? License law, GREC Rule 520-1-.09 states that a licensee shall not advertise any real estate for sale unless the licensee has first secured the written permission of the owner or the owner's authorized agent, i.e. the broker, or the owner of a leasehold estate. When such permission is granted, a licensee advertising real estate that is listed with another firm shall clearly and conspicuously disclose the name of the listing firm unless that listing firm has expressly agreed in writing to waive those clear and conspicuous disclosures. So then the next question you should be asking yourself is, what about IDX reciprocity? That stands for Internet Data Exchange Reciprocity. Those are those agreements you get signed from various MLS services. Brokers do them, and you guys as agents do them to be able to, in essence, advertise and market all of the listings in that MLS on your website or on your broker's website. Those IDX reciprocity agreements only extend to broker and agent websites with the signed IDX reciprocity agreement. This permission does not extend to your social media. Just because you have an agent website or your broker has a website where you're basically showing all of the MLS listings, that does not give you permission. That is not part of license law. You do not have written permission of the authorized agent to market that property on your social media, just on those websites. Okay, moving along under the seller brokerage agreement. Okay, now I'm going to have to hurry up. What time is it? Okay, sharing of commission and MLS membership. This has been the case, but this is being spelled out for clarification for brokers and agents. Basically, again, this is the listing agreement. And if you buyer's agents, if you find a property for sale and that listing, let's say that listing is listed in an MLS service, and in the MLS printout, it shows a co-op fee. If you are bring a buyer, you're the procuring cause of sale for that house. If you are not a member of that MLS, that is not a contract for you to get paid by that seller or listing broker. So here's what it says: sharing a broker's commission with cooperating broker. And it talks about the commission. None of that's changed. What changed was this addition at the very bottom in 2023. Seller's broker shall have no obligation to pay any cooperating broker who is not a participant of any of the multiple listing services in which the property is listed a commission, unless that cooperating broker has negotiated and executed with the seller's broker a co-op commission agreement. You buyer's agents, stop working for free. You need to protect your commission. And the MLS, if you are a member of the MLS are membership driven services, and membership has its privileges. If there is a property listed in an MLS service, but you're not a member of that MLS service, you are not guaranteed that co-op commission. You need to use this form, co-op commission, to be used prior to showing. It's GAR F258. Y'all should get that signed. You buyer's agents need to get that signed from the listing agent as a contract for your commission if you are not, if you're showing a house and you're not a member of the MLS service. I also suggest that you do this with new construction that's not listed, because there's not a promise of a co-op fee in an MLS listing. Just be aware of this. Again, MLS services are membership based, and FMLS, under their rules, they say that it is the duties of the FMLS office is to act as a central processing and distribution point for the benefit of members. Georgia MLS says the multiple listing service is a facility for orderly correlation, dissemination of listing information, blah, blah, blah. A means by which authorized participants make blanket unilateral offers of compensation to other participants. Again, members, MLS services are membership based and have their privileges. Is that a new form? No, this form is not a new form. It is just not widely used, and it should be used. You buyer's agents, y'all, even if there is a promise of a co-op commission in an MLS service, even if you are a member, I do not understand why y'all do not either use this or use the instructions to closing attorney and get a contract for your commission between the seller's broker and the buyer's broker in writing at time you go under contract. I don't know why y'all wait for this at the end. The commission, again, some of this has changed, and it is either buyer driven by the buyer brokerage agreement, but if you're expecting to get paid from the other broker, y'all need to contract for that. That has nothing to do with the buyer and the seller. That's an agreement between brokers. Yes, definitely a good idea to use with the builder. Okay, another chat question. If you have instructions to the closing attorney, do you still need this? If you are a member of the MLS, I would definitely get the signed commission instructions. This might be a good idea to use before showing if you think that co-op commission being paid by the seller or the listing broker is going to be an issue. Then yes, this is available to use in any situation, regardless if a property is in an MLS service or not, and regardless if you are a member of that MLS or not. All right, moving along. Also in the listing agreement, again, just a reference. They just teased out the lead-based paint disclosure, and they have referenced the actual exhibit. They teased it out from the seller's property disclosure form. Same information, it's just reorganized a little differently. This is under the seller's property disclosure statement. They've done a couple of things. They had information about lead-based paint that they moved to its own paragraph, and they've added this term. Georgia law, and this is the Georgia frauds law, requires that a seller disclose known latent defects in the property which could not be observed by a buyer upon reasonable inspection of the property. In 2022, they just took out the word known. So in 2023, they added it. Again, just really trying to clarify that. Obviously, a seller cannot disclose something of which they have no knowledge, but they added that in there nevertheless. I have some information here that you guys will get in a copy of the PDF handouts, but I'm not going to spend the time. Well, let me see how much more I have to go. Yeah, I've got a few more slides, so I'm not going to spend as much time here, but general information about seller's disclosure. This is all spelled out. In Georgia, sellers do not need to disclose certain things that happen to the property. So this is the stigmatized law rule. Seller does not have to disclose if somebody had an infectious disease, if somebody died in the home, or if there was either by murder or by suicide or felony. They do not have to disclose that in and of themselves. However, you listing agents and you sellers, well, if you're working with a seller, if you are point blank asked, is this the house? Did anybody die in this house? You must answer truthfully. The only thing you do not have to answer is if someone in this house had AIDS. That is protected, and you do not have to answer that question, even if asked point blank. These are just the laws citing this. Again, also, seller does not have to, by Georgia law, disclose if a registered sex offender lives in the area. And that's why that information is in the purchase and sale agreement, is that the buyer is directed in their due diligence to check that out for themselves. These are the laws on stigmatized property. I just wanted to let you know here is the reference for you. This is the question: as a listing broker, are you required to disclose if a murder or suicide? Again, if point blank asked, except for the disclosure of AIDS, that is confidential information. Even if you are point blank asked, you do not have to answer that. However, if you as an agent have knowledge of a latent material defect, you, by virtue of your license law, you must disclose that, even if your seller tells you not to. And these are the laws regarding that. These issues are also addressed for realtors in the Realtor Code of Ethics, Article 2. And just wanted to point those out to you, so it's references for you should you need them. All right, moving along, under definition, still in the seller brokerage agreement under miscellaneous, they've just defined what NA is, and it just says, it's a new subparagraph that says the use of initials NA means, it just defined it as meaning not applicable. Now, here's a note to you guys. If you are negotiating a contract between a buyer and a seller, and you are using the counter offer form during those negotiations, you're not going to use NA because that term is applicable. You are just going to use NC, that stands for no change. And this is actually spelled out on the counter offer form, GAR F249. It says, the following terms and conditions of the original offer are made as follows. The sections not filled in or marked NC for no change, which means no change, is being proposed to that section of the agreement and shall not be part. Don't put in NA in the fill in the blanks on a counter offer. If the broker is a member and the agent is not. FMLS, I'm going back to a chat question. FMLS requires, if the broker is a member, all agents must also be members of FMLS. Georgia MLS allows for a broker to be a member, but not all agents to be a member. Regarding other MLS services, I am not aware of all of the rules and regulations and membership agreements of all the other MLSs. Okay. Moving along. Temporary occupancy agreement for the seller after closing. Lots of changes in this one too. They've added at the time of closing. So this is a situation that you go to closing and the buyer now owns the house. but the seller is going to stay in the house for an extended period of time, up to 60 days, you are going to use this temporary occupancy agreement for the seller after closing. It states at the time of the closing, the seller shall provide the buyer with one set of keys. That's always been in there. And what they've added is at time of closing, the seller is also to provide the buyer with door openers, codes, and other similar equipment needed to access the property. And then at time of possession, the seller gives over everything. So they've added the door openers, codes, so forth and so on. Additionally, they have added in the temporary occupancy agreement additional responsibilities of this for the seller to maintain the property while they are in the property. And it says, paragraph 8 in 2022 said, seller shall be liable for the expense of repairing any damage to the property caused by the seller, seller's family members, licensees, and invitees, including normal wear and tear. Buyer, as the new owner, shall be responsible for making all other repairs to the property. At the end of that paragraph, they have also added for 2023, notwithstanding the above, seller agrees to continue to perform all routine maintenance during seller's temporary occupancy of the property, including, by way of example, cutting the grass, keeping the property clean and free of trash and debris, maintaining pool chemicals, changing filters, light bulbs, batteries, so forth and so on. Seller shall promptly report to buyer any obvious need for maintenance and repairs. Additionally, there's more information, a brand new paragraph about the buyer's right to access the property. Upon 24 hours advance notice to the seller, buyer and buyer's representatives shall have the right Monday through Saturday from 9 a.m. to 8 p.m. and Sunday 1 to 6 to access the property to inspect, repair, maintain the property. In addition, buyer and buyer's representatives may enter the property at any time to investigate potential emergencies, evidence of water leaks, fire, smoke, foul odors, sounds indicating the possibility of an injured person or animal, or other similar evidence of an emergency shall be sufficient grounds for the buyer and buyer's representatives to enter the property for this purpose. And then they have also added under the section about a holdover tenant, they've added at the end of the section. So this is where the buyer and seller negotiate. If the seller is going to stay in the property temporarily after closing, you negotiate an amount that the seller will pay the buyer if they do not vacate when they say they are going to vacate. So that's already in there. And then what they've added to the end of that is the holdover rent is intended to partially compensate the buyer for lost damages and expenses, including delaying the buyer's possession and the additional cost to move associated with the delay or ability to secure a replacement tenant, or causing a sales transaction to be terminated or postponed. If buyer incurs additional costs due to the delay or loses a prospective tenant or sales transaction because the seller fails to, that should be vacate property upon expiration of this temporary occupancy period, seller will be liable for such damages as buyer can prove because of seller's wrongful failure. This is a huge thing. This means if the seller says in this exhibit, in this agreement, the seller says, I'm going to stay in the property for 5 days until whatever date after we close. If the seller does not leave at that time, the seller agrees to pay the buyer this amount of money per day for being what's considered a quote unquote holdover tenant. This new paragraph in 2023 says the buyer, who's now the new owner of the property, may incur additional damages and costs because the seller didn't get out when they said they were going to get out. This now lays the groundwork for the buyer, who's the new owner, to pursue the seller legally and civilly for additional costs above this amount if they can prove additional financial damages due to the seller not leaving when they said they were going to leave. And they've also added, you guys as agents have done a great job professionally protecting your buyers and your sellers regarding this, but GAR has just spelled this out regarding property insurance to both buyer and seller. It's all in caps, and it says prior to the commencement of this temporary occupancy period, buyer and seller are advised to consult, sorry about the misspelling, with their respective property insurance agents to confirm that their real and personal property, as the case may be, will be insured during the temporary occupancy. You listing agents working with sellers, once they close, they no longer own the home. They no longer have homeowners insurance that covers that property. You buyers agents, your buyers now have insurance on the structure itself, but your sellers, they need some sort of policy that covers their personal property items, like renter's insurance. All right. Brand new form. So remember when we talked about a buyer assigning a contract? Okay, let me go back. There's one question about eviction rules. If you have a seller, a buyer and a seller have signed a temporary occupancy agreement for the seller to stay in the buyer's new home for a time frame after closing, not to exceed 60 days. If it's after 60 days, you need a lease, and the buyer needs to let their lender know, because they're going to get an investor interest rate rather than an owner occupant interest rate. But if it's shorter than that, it does not create a lease in Georgia. Why? Because if there's a lease in Georgia, landlord tenant laws kick in that we don't want to kick in. However, if a seller stays in a buyer's property and don't get out when they say they're going to get out, they are considered a quote unquote tenant at sufferance, and the buyer / new owner is still going to have to go through the eviction process at the magistrate court level to evict them. So it's not a lease, but those procedures are still the same. Okay. Woo. Okay. Moving along, new form. If you are working with an investor, if you have a seller that has sold to an investor, again, the GAR contract is not assignable without the seller's written permission. There are 2 GAR special stipulations that you would include in that, and they are referenced here. 610 assignment, 611 seller's consent to assignment of purchase and sale agreement. Just know that would be in the purchase and sale agreement. There is a new form amendment to assign the agreement. I apologize, I do not have a copy of that form as of the time of this class. I will make it available as soon as I get the training copies from GAR, which should be any day now. Oh, we made it. That's it. Woo. So thank you guys so much. I hope y'all enjoyed and learned a lot.
Just one time.
A couple of things. Please confirm all contract questions with your broker. We have additional classes. You can see what those are, register for reclasses.com, select your geographical area, or you can select Marietta for all virtual classes. They are offered through the Real Estate Academy of America. Here are where your handouts are available. CE credits will be recorded within 3 to 5 business days. There is a reference to my YouTube channel where I go into a lot of these issues in a lot more explanation in depth, not only contract issues, but the RE forms, license law issues, code of ethics issues, a ton of information on my video channel. If you are leaving, one more time before you leave, please type in your name, real estate license number, email address, and phone number in the chat. I pray that God helps you be a blessing to any and everyone around you with their real estate needs, with respect to the real estate license that you have worked so hard to earn and to keep, and with your chosen profession and chosen career. I will stay on for any questions. Thank you guys so much. I enjoyed teaching. This is the first time, so I can't believe I finished on time. For those of you guys that know me, you know that I can be wordy. So I'm going to stop the share because everybody is typing so much in the chat. Thank you. Yes, Merry Christmas, everybody. If you do have a question, please feel free to unmute yourself, but mute yourself back so we can all hear the questions and the answers. I hope you guys got a lot out of this class. Lots of changes, but nothing major, but very interesting. So I'll be more than happy to stay on for questions.
Hey, Dana, can you put that screen back up that you just had?
You got it. Absolutely, Gary.
Thank you.
You're welcome. One hint, you guys, let me share my screen. Whenever you guys are taking a virtual CE class, it's always a great idea. Gary's probably going to do this, but it's always a great idea to have your cell phone handy, and you can always take a screenshot of what's on the screen. That's just a very quick and easy way to get the information on your phone without having to madly write anything down. But there's that information. Also, you guys know we are working on coming up with a website for the Real Estate Academy of America that will make it much easier for all agents in Georgia to find our CE classes, register for our CE classes, our virtual ones, our ones that are in physical locations. So we are working on that. That is a huge priority for us in 2023. All right, any other questions?
Joseph Winkler, how'd you get that nice background behind you?
When you're on Zoom, when you click on the little icon that says video, there's an option for you to add, to either blur your background or add a virtual background. So play around with Zoom. That's a Zoom thing.
Yeah, nice. I don't want everybody to see how bad my housekeeping is.
Anybody else? What do y'all think? Gary, is that good? May I take it down now? You have all the information you need?
So that Real Estate Academy of America, that's where you can take your CEs or find your classes?
We don't have that up yet. That we are working on that to come up with a website that's a lot easier. Right now, where you're going to go is register for reclasses.com. And you'll see a list of geographic locations, or you can click on Marietta to get the master list of all of our virtual classes. We have gotten feedback from you guys as agents throughout Georgia that it is a bit difficult to find our CE classes. We also send out an email at the end of every month of the upcoming classes for the following month. So we are making that a priority to make that easier for agents throughout all of Georgia to be able to find our classes and register for our classes a little bit easier. Merry Christmas, everybody. Happy Hanukkah, everybody. Happy New Year.
Hey,
It's gonna be
Dana,
a good year. Yes.
Dana, I just wanted
Yes,
to tell you, you did a spectacular job. Normally, when I do these web things, I usually fall asleep, but you had my attention from second to second, and I love your voice. Just so that everyone knows, you're great. You're great on so many levels.
Thank you so much. I am very humbled and appreciative of your comments. Teaching is one of my absolute favorite things to do. I've had a real estate license for about 27 years now. I did enjoy working with the public. I now enjoy working with agents and co-op brokers and that part of it. But probably my favorite thing that I do is teach. I absolutely love teaching, and I make an effort to teach in a way that makes the information accessible to you guys as agents, not blah, blah, I'm here for a class or I have to memorize this, but I try to present the information in a way that it makes sense to you. So when you're on your own, or you're writing a contract in the field and can't get in touch with somebody, or you're writing a contract at 11:30 at night and can't get in touch with your broker or another agent, that you can sort of think through the process yourself, or you'll know, oh gosh, I know that somewhere in the contract. Let me go back and see what the contract says. That you are directed to think through these things. Number one, to protect yourself. Number two, to protect your client. And number three, just this is the profession you have chosen. And these are the items that you use. And just to have confidence in helping people and being a blessing to others with the contract. So I appreciate that. And again, I love doing this, and I'm very humbled and honored by your kind words. And it is just confirmation that just to glorify God for the talents He has given me And I get confirmation that this is one of them. So thank you for that confirmation.
Dana,
Take that and look
Yes.
for some more classes from you.
Awesome, thank you.
Dana, can we,
Yes, ma'am.
I really don't like the backup form, the new backup form. I mean, the old backup form, which is, and you probably know why, because it used to be in days of old when we did backups, correct? That we could put in there as a backup agreement and nothing would take place until we were notified that we were in primary position. But am I wrong in interpreting the backup form that we have? It states that everything takes place as soon as we are accepted as a backup.
You are wrong in that interpretation. And I
Okay, that's what I was like.
apologize if I did not describe that fully. Let me actually pull up the backup agreement and show you guys. While I'm doing that, let me explain to you backup. So the only thing that happens is you are still correct. That is still the case that a buyer that is in backup position, none of their timeframes kick in until they are notified that they are primary, with the exception of earnest money. Earnest money is still to be remitted to the holder within so many days from binding agreement date. Their binding agreement date is still the time they go binding as a backup contract. Now, it says in the backup agreement, and I'm going to show you guys what that looks like in just a second. It says in the backup agreement that all other timeframes, all other contingency timeframes, due diligence timeframes, so forth and so on, all of that kicks in once the buyer, the backup buyer, has been notified that they are now the primary contract. So all of that is the same. So let me show you. Hang on one second. And I'm going to show you. I'm pulling this up in the background while I'm talking. All right. Let me share my screen and let me show you guys where this is, because I don't want anyone to be confused on this. So this is the backup contingency offer. And none of this has changed. Again, none of these terms have changed. What has changed is the reference to additional backups. So here's where it says, this is the backup contingency exhibit for 2022. It references the primary. Again, the only change for 2023 is there's going to be more, but the rest of this is the same. Here we go. It's under this paragraph. In the event the primary agreement is terminated, the seller shall deliver notice of the same to the buyer. This backup agreement will become primary and is no longer subject to this contingency exhibit, and buyer and seller shall close in accordance with the terms and conditions, provided that, notwithstanding anything the contrary, the time limits, except the delivery deposit of earnest money. That should already have taken place when they went binding as a backup. But all other timeframes and time limits shall commence on the date that notice of the termination of the primary agreement is provided, and as long as the closing date has not passed. So then it goes on to say, closing because of the change of the binding agreement date. Closing date shall be the date listed in the agreement unless, because of the change in the binding agreement date, any of the time periods for the buyer to conduct due diligence or fulfill other contingencies of this agreement extend beyond the closing date. Okay, that's not what I was looking for. Where does it say? Somewhere it says that basically all other timeframes, shoot, I cannot find it on the fly, but basically it says that all other, maybe it was here. All other timeframes kick into place once the backup buyer is made notified that they are primary. All other timeframes come into play except for earnest money. So the binding agreement date is still the date that the buyer and seller went binding with the backup contingency exhibit. All the other timeframes, due diligence, all that stuff, day 0 for that is the date that the seller sends written signed notice to the backup buyer that they are now primary. That date now becomes day 0 for all the other timeframes in the contract, due diligence, financing contingency, and appraisal. So I hope that explained it. Why is my face so big? All right. Any other questions?
I just wanted to give thumbs up to great class. Time went by really fast. I think you should have contracts part 1, part 2.
Well, just so you guys know, we're going to teach this class again in, throughout December, January, and February. After that, we teach another class that's going to be called the 2023 GAR Contract Dissection. That goes through the entire contract, everything. And then we have another class that is specifically on the buyer brokerage agreements, other amendments, and other special stipulations. The purpose of this class was really to highlight some of the primary changes that the Georgia Association of Realtors has made for 2023. Not really go through everything. I just can't help myself when I have a moment to educate, teach, and inform, remind. I try to do that for your protection, for your license, as well as for the protection of the public with whom you work. But yeah, it's a lot of information.
And one other thing, what was your YouTube channel? Did you say Real Estate Tips Made Crystal Clear?
It's just called Real Estate Made Crystal Clear.
All right.
And I go into a lot of these issues way more in depth with examples. And like I said, there's 4 or 5 years of information on there. Lead generation ideas, contract tips, all contracts, license law information, all kinds of stuff.
Okay. All right. Thank you.
My pleasure. Anybody else? All right.
Thank you so very much. It was very informative, and I look forward to taking your classes, and I will go to the YouTube channel.
Awesome.
Have a great holiday, everybody.
Thank
Take
you
care,
so much.
Dana.
Hello, Monica. I did not see you on there. Made it. Not bad on a couple hours sleep.
I know, yeah, really. You did amazing.
Thank you so
But I
much.
expect nothing less.
You're so sweet. I will share as soon as the school has paid for the training copies from GAR. So as soon as I get those, I will share those. I will go through, underline, and I'll update things. But with what we had, hopefully I made a lot of information understandable and enjoyable. And that's it. So I thank everybody so much. I don't think there are any more questions. So I'm going to end right now. And thank you guys so much. Merry Christmas, Happy Hanukkah, Happy New Year. God bless. Enjoy God's blessings, all of us. Thank you all so much.
Thank you. Bye.
Bye.